Hello, everyone, and thanks for joining us during what has been a very busy week for public schools. We're going to address today a topic that we know hits home for a lot of people throughout the state of California and throughout the United States of America as we discuss immigration policy and resources. Again, we know this is a delicate issue, and we are going to try and honor that by providing all the information available to us at this time. On the other hand, this is still a very fluid situation, so we won't have complete answers to every question, but we're going to walk you through all the knowns and then perhaps a little bit of speculation about what you might expect, but not too much as we don't want to spread any misinformation. And so today we will start by looking at what the status quo regarding immigration enforcement on school campuses was prior to January 20th. Then we will look at what has been announced in the form of directives and executive orders since January 20th. And then we'll look at how that changes the status quo and what new expectations and new obligations and responsibilities you have as school governance teams and school staff in terms of supporting your students while also complying with state and federal law around immigration enforcement. We will get to the substance of our presentation in just a moment, but before that, I'd like to address a couple of housekeeping details to help you participate in today's event. You see there in the red box, that is the Q&A section. Those icons are used to submit questions. Please don't use the chat function. We ask that you use the Q&A function. And those questions will be stored there to be addressed at the end of the formal presentation. So questions will be addressed at the end. Don't become impatient. We will get to them. And this session is being recorded. A copy of this recording will be sent to every registrant tomorrow morning, along with the PowerPoint presentation, the slide deck that our panelists are using. And now I will introduce those panelists. We have with us today Kristin Lindgren-Bruzzone, General Counsel here at CSBA. We also have our Chief Policy and Governance Technology Services, Joshua Daniels, and our Deputy Legislative Director for State and Federal Programs, Erika Hoffman. I'm your moderator. I'm Troy Flint, Chief of Communications at CSBA, and now I will turn it over to my colleague, Kristin, for more information.
Good morning, everybody. We know this is a kind of tough and turbulent time with a lot of information flowing. As I was creating these slides, it felt like I got an email every few minutes that made me have to change something. So we're doing our best in a time of pretty significant uncertainty to give you the most up-to-date information about where we are with legal aspects of immigration law for LEAs. We'll continue to update you and issue updated guidance as things grow and change and we're able to get more information and maybe see some things that are actually happening. So for now, we don't know exactly what to expect, but we want to provide you what we do know. We are in a time where even long settled law that we all sort of relied on and were sure about is now subject to change and is being challenged and has been changed. So we want to make sure that we let you know what those are. I do want to note just at the front end that current executive orders that the new administration has issued do not focus on schools. We don't have a specific set of rules yet other than the DHS directive that I'm sure you've all heard about that I will talk about more in depth. And the also current executive order does not focus on immigrants that are accused of crimes outside of violating immigration requirements. So this is a pretty significant set of directives around immigration enforcement that likely will have some impact on schools. Next slide, please. So existing law on immigration as it impacts schools is still good law for now. And I'll talk about kind of where we are at the end of my presentation. But Most of you are familiar with Plyler versus Doe. It's a 1982 U.S. Supreme Court decision. That means it's 43 years old, and I know none of us want to think 1982 was 43 years ago, but so it is long settled U.S. Supreme Court precedent, and that held that undocumented students must be provided with equal access to public education, regardless of their immigration or citizenship status. And that is based on the Equal Protection Clause of the 14th Amendment. And essentially what the court said was, if you offer public education, if a state offers public education to some students, it must offer it to all. And immigration status is not a basis for discrimination in the offer of public education. So that is still good law. You are still obligated to provide equal access to a public education regardless of immigration status. One thing that doesn't come up as much is the Fourth Amendment to the U.S. Constitution's protection against unlawful search and seizure. So the Fourth Amendment protects all of us from unlawful searches and seizure by the government, typically law enforcement, in spaces where we have a reasonable expectation of privacy. In immigration, that has been interpreted to mean that immigration enforcement is allowed in public spaces without a judicial warrant. So like parking lots, sidewalks, things like that. Typically, it has been the interpretation that inside of a school is not a public place, and that in order to enter school facilities, then a warrant would be required. These are the kinds of things that are currently up to challenge and debate. We may see different Supreme Court decisions, different interpretations, so just be aware, but that's the interpretation currently. And then also we have FERPA, which is the Family Educational Rights and Privacy Act, that protects student records from disclosure, absent consent of the parent or guardian or a student who's 18 or over. And so some occasionally immigration enforcement has sought student records, and FERPA still protects student records, but does allow them to be disclosed with consent or warrant or court order. So you can follow your typical process if you get a request for student records. And as I'll note in the next slide, you shouldn't be maintaining records of immigration or citizenship status anyway, but you could get a request, and just be aware that FERPA does not have an exception for immigration, except to the extent that an immigration officer presents you with a warrant that is, or a court order. Next slide, please. So state immigration law, just in general, the California Constitution provides all students a right to attend campuses that are safe, secure, and peaceful. I've got the citation of the Constitution there. In 2017, AB 699 was passed by the legislature and signed by the governor. It amended some of the education codes and then added a couple. And in short, and I'm not gonna go into it too much, and some of this is also in Josh's presentation about policies, model policies. So he'll talk about it a little bit more as well. But these 5 bullet points are kind of the essential pieces of AB 699 that you should still be following. It does have some pieces that do anticipate the detention of a parent, for example. So there are some requirements. If a parent is not available to pick up a student, you are to seek the whatever adult emergency contact before you call CPS. So the idea is to protect students from further issues when their parents are being detained. It does require you to provide information regarding immigration rights. So there's some requirements there to help families understand their rights. And then it does require the Attorney General to publish model policies, and that you are to adopt those or the equivalent. And again, Josh will talk some more about model policies in his part of the presentation. I did include some links to the Attorney General's current guidance on model policies. They were updated in December, so they have not been updated since the inauguration of the new administration. So just keep that in mind. But they generally follow AB 699. And then they do also include a quick reference guide that might help if you do have immigration enforcement that is occurring on campus. Next slide, please. So, new authority that's been issued this week. We have an immigration executive order. It's called Protecting the American People Against Invasion. That's what we're referring to. If you want to read the executive order, you can just Google search that and it'll pop right up. As I noted, it's not specific to schools. It doesn't address enforcement in schools. The word school isn't even used. It's more of a general order setting forth the expectations of the president for immigration enforcement, and setting forth several different pieces. I want you to take special notice of Section 17. It requires the Attorney General and the Secretary of the Department of Homeland Security to address what are called sanctuary jurisdictions. Our understanding is that this is pointed at sanctuary cities and sanctuary states. California, I believe, has designated itself as a sanctuary state, and we haven't heard anything from the governor or the attorney general of the state on what their interpretation is of this piece of the executive order. But I want to point it out that there is a risk to designating any local agency, including a school district or a county office of education, as a sanctuary jurisdiction, in that they are threatening federal funds for sanctuary jurisdictions and also threatening criminal or civil penalties. If you have questions about this is a great time to reach out to your legal counsel. CSBA's Legal Services also provides information on this if you want to sign up with them. But this is a really evolving and uncertain area of the law right now. And but we do have also a DOJ memo that has directed federal prosecutors to investigate any state or local officials who are accused of standing in the way of any immigration enforcement. So I just want you all to be aware that that is the current policy of the presidential administration right now. And so it does present some risk and some risk assessment that needs to be undertaken about how you want to proceed, and also ensure that you're following state law. So really encourage you to reach out to your legal counsel if you have designated your district as a sanctuary district, and find out any kind of risks legally that you might have there. And it looks like Erika has a comment too.
Yeah, Kristin, I just kind of wanted to say this is a big, huge question issue nationally. It's not just California, but it does feel like that at points in times. One thing I will say is that the Justice Department, in conjunction with all of this, the federal Justice Department has put together a sanctuary cities enforcement working group. And part of it is to look at potentially what they would need to do in the case of lawsuits and things of that nature. As Kristin said, doesn't specifically mention school districts. However, the language in it is broad enough that the interpretation is there, because it basically says and anybody who interferes with this. So it is something just to kind of keep in mind. We do have, specific laws in California that look at issues of, what you should and should not provide. Kristin mentioned the AB 699 legislation. Wanted to briefly mention there has been one piece of legislation introduced, SB 48, which has not had a hearing yet because of, deadlines we have going on here, but it would prohibit school districts from granting ICE or other officials access to a school campus. So this is going to be a long, drawn-out issue. So just kind of keep that in the back of your mind for right now. At a point in time, we will start having hearings on this. More information is going to be coming out, especially from Federal Department of Justice, but also from Attorney General Bonta and the Department of Justice here. Other than that, there has not been other legislation introduced, but trust me, there will be. Deadlines for introducing bills is in February. So I would expect quite a few more pieces tied to all of this to come out, and we'll make sure to keep updating our information that we send out to you guys. So just kind of wanted to add that on top of what Kristin had talked about.
Yeah, the state of California is certainly going to react to those things. We just don't have a lot of that reaction yet because it's only been a couple of days. So it's just a kind of watch and wait type situation to kind of see where that sweet spot is, where you're making sure you're, meeting federal requirements and state requirements. And this is a really good time to use your legal counsel. They're all keeping track of this as well. So just to kind of note, one question we've been getting, and you can go to the next slide, Che, is what authority does an executive order have? It's not a statute that's gone through both houses of Congress. It's not a regulation that has gone through public comment. It's not a Supreme Court decision that has gone all the way up to the Supreme Court and gotten an opinion. And unfortunately, they haven't been challenged a lot. And so it's a gray area without a lot of legal authority. I would say they're not equivalent to a federal statute or a Supreme Court precedent. But what's less clear is if they supersede state statutes. And, the lots of things are under the Constitution left to the states to make their own decisions about how to handle things. Immigration is not one of them. It is squarely within the authority of the federal government. And so an executive order on immigration probably carries more authority than an executive order on whether we can protect, for example, certain types of students in schools, which is more typically left to the states. So just keep that in mind, and that the Department of Justice under President Trump has taken the position that any federal action supersedes any state and local laws due to what is in Article 2 of the Constitution regarding the president's authority over national security and immigration. So again, it remains to be seen how Governor Newsom, the legislature, and Attorney General Bonta will react to this. The Attorney General Bonta did react to part of the DOJ opinion, which provides that local law enforcement is required to assist with immigration. In California, that's unlawful. So there will be a fight there that doesn't really impact you all, but otherwise we haven't heard from them on their position on that. So just keep in mind that, again, this is sort of a gray area, but this is what the position that the administration has taken, is that state law is not equal to any federal action that the administration takes. Okay, next slide, please. The other big piece of information or news that came out this week was that the Department of Homeland Security did rescind 2021 guidance under the Biden administration that made schools, hospitals, churches, and other areas consider protected or sensitive areas where there would not be immigration enforcement. This was not a surprise. This was reported that this was the plan. This is well within the president's authority, to rescind. There could still be challenges. There could be states that challenge this, but this was an attempt to keep some areas sort of sacred for folks to be able to still gather, go to church, get health care, go to school, and that is no longer the case anymore. So we have not seen the actual memo from the acting DHS secretary. We've just seen a statement, and then the memo was leaked to some members of the media. So we understand that what it says is the immigration officers, like ICE officers, can use their discretion whether to enforce in these areas, and that they're expected to use common sense when doing so. As you can all imagine, common sense is not a legal term. It is up to a lot of different interpretations. So this is one of those pieces where it remains to be seen how ICE and various ICE officials and supervisors will direct their staff to conduct enforcement. And it could be different in different areas depending on who is in charge. So that is a place where it remains to be seen whether they will actually conduct enforcement actions in schools or not. It is really up to them. Although the message they may be getting from the executive order is that they are expected to enforce everywhere. So it's unclear at this point. the Fourth Amendment still applies. So, you know, assuming that schools are considered, their indoor buildings are considered private and not public places, we believe that a judicial warrant is still required for them to come into school places to do immigration enforcement, make detentions or arrests, or they have to say that there are exigent circumstances, which means there's an immediate threat to public safety and that they're required. You know, for example, they're chasing someone and he runs into a school building. That would constitute exigent circumstances for them to come inside without a warrant. So that law still applies as of now. And so we'll talk a little bit about the practicalities of what to do if an officer does show up with a warrant. Next slide, please. And Josh has some great information from our sample policies that he'll go over with you as well. So where are we now? Plyler versus Doe remains good law. It may be challenged. I remember hearing that the state of Texas was looking into challenging it at one point. We can expect that probably to go back to the Supreme Court, but for now, you are still legally obligated to educate students regardless of their immigration or citizenship status. Based on what is in the executive order and other information that has come out from the administration, AB 699 appears to be consistent with what is currently known about the presidential administration's policy. So you are still obligated to follow those requirements I went through in my slide about state law, including not maintaining documentation about student immigration or citizenship status, and ensuring no discrimination against students based on their immigration status. FERPA still applies. It still prohibits providing student records unless there's a warrant, parental consent, or court order. You should not be keeping records of immigration status. So that should help you avoid any requests for that. But if you receive subpoenas or warrants, you want to call your superintendent and have them, or if staff receives it, they're going to want to call the superintendent and have them reach out to legal counsel and get some assistance on how to handle that. There may be enforcement in schools that would not have occurred under the original guidance, both from 2011 and 2021. But we do suggest making sure that you are taking steps to address when an officer comes to a school site or other school facility, and make sure that you are looking at the paperwork that they have, getting information about why they are there. And again, Josh will go through kind of these steps that are already in existence and our sample policy and some changes that we'll be making. And then, you know, ultimately just expect uncertainty. There's going to be significant litigation around all of these issues, likely. You know, the state of California has already signed on to a lawsuit that addresses President Trump's executive order regarding birthright citizenship. The legislature has set aside, I believe, $50 million to continue those kind of challenges against presidential action, and they're currently in their special session about that. So we can expect more litigation. We can expect bills, more bills from the legislature, as Erika noted. And this is really just a place where we're going to have to watch how the law changes and evolves. And be aware that the Congress, the Supreme Court, and the president are all held by one particular party, and so that gives them a little bit more authority and flexibility here. And the states have a bit of an uphill battle. Next slide, please. So what should you do? Continue to follow your policies regarding immigration enforcement at school sites, provide training to staff on what they should do if they are confronted with immigration enforcement at a school site. Be proactive, come up with a plan before you need it, so that everybody knows what their expectations are and staff can get appropriate training. Always contact legal counsel for assistance if you need them to review a warrant to determine whether it is a warrant that they have to comply with. I and Josh will go through this, but ICE does also have something called an administrative warrant that does not require compliance. And that's going to be hard for the secretary at the front desk of a school to understand. So you want to have some training and plans in place and how to contact legal counsel if in fact this happens. But at the end of the day, no one is expected to enforce the Fourth Amendment against immigration officers. Don't obstruct them. If you believe they're overstepping their authority, that's for that to get dealt with at a later time. We don't expect staff to be the, you know, the enforcers of overstepping authority. You know, it's just they have a lot of authority, and so while we do not want to just open the door to anyone and let them run free, if they insist on going into a school site or facility, then let them go. And then, as best as possible, you know, under the Constitution, we are required to provide a safe and nurturing climate for all students. So continue to do that, work with families, you know, provide them their notice of rights as required by AB 699. This is going to be a difficult time if we start seeing enforcement on campuses. People are going to be scared. Students might not show up for school. And, you know, you can only do what you can do within the requirements of the law to make sure that they feel supported at school. I'm going to hand it off to Josh to talk more in depth about the sample policies.
All right, thanks, Kristin. Good morning, everyone. Nice to see some familiar faces on the list of attendees. Wish it was under different circumstances. But I'm going to talk to you all about our sample board policy and administrative regulation 5145.13. The title of that one is Response to Immigration. I see a number of questions in the Q&A. I'm hoping to get to some of them, but obviously we'll get to more of them during the Q&A portion of the webinar. All right, next slide, please. So before we jump into the details, just want to give a little bit of background on what our sample policies are. So we provide samples. Those are starting points for districts and county offices, not ending points. The expectation is that you will review each policy or update and then adjust them, you know, comply with the law, but adjust them according to your own needs and context. The policies have gone through legal review, but they're not legal advice. There's not an attorney-client relationship between, you know, the CSBA policy services and our members, and often they can become out of date. So definitely have your counsel look through them, and again, they serve as starting points, not ending points. There are notes embedded in the documents, although those are not part of what you should be adopting. They're like annotations, basically, to help you understand various pieces of the body language of a sample policy. Next slide, please. Okay, so in terms of 5145.13, most of it comes from Ed Code 234.7. This was what Kristin mentioned earlier. It requires districts and county offices to adopt policies consistent with the AG guidance. This was back in 2018. So we did put out this 5145.13 subsequent to the AG's guidance in 2018. And we are going to be releasing updated, and I think in the next update, updates to this sample policy that will reflect what the Attorney General just put out in December. For the most part, though, since the underlying law hasn't really changed much, the current version of 5145.13 is going to be pretty similar to the updated version. So one question that I saw in the Q&A was, do we have to update our policies based upon the 2024 guidance by the AG? The way that it is worded in the guidance is that you should update your policies by May 1. Now, the law itself says you just have to update your policies by 2018 based upon the 2018 guidance. So it's unclear if the AG were to update their guidance, does that then sort of automatically require LEAs to update their policy? So that's a question you should talk to your legal counsel about. Just wanted to sort of give you the context that like the current 2024 guidance says that you should. The law is less clear, so you sort of need to decide it at the local level. You may want to, of course, and we are putting out an updated version of 5145.13 because we know that many LEAs will want to. Okay, next slide, please. Okay, so without guaranteeing what's going to be in the updated version, some of this is not really changed from the current version, but I wanted to give you sort of flag some of the major concepts and the major pieces that you can expect to see. Until it's actually published, we reserve the right to make changes, but definitely want to give you a sense of what's coming. It'll also give you a sense of sort of what the law requires. So there's general language about you cannot deny students equal rights, opportunities, no discrimination, no harassment, etc., based upon, among other things, a student's immigration status or the refusal to provide information about a student's immigration status. You're required to be notifying families about the children's rights to a free education, regardless of immigration status, and things of that nature. And there is a requirement that staff receive training around these issues. Next slide, please. Okay, so this is getting to this is a list. At least the first are a list of things that staff cannot do. So you cannot solicit or collect information or documents regarding immigration status. You cannot like ask about or require documentation about immigration status for any sort of educational purposes if you can get that information other ways. So if some document would reveal, if you have two documents that you request, and one says, the immigration status and one doesn't, you're going to go with the one that doesn't. And this is the one that Kristin alluded to, and this is the one that a lot of Q&A questions are about, but you cannot provide assistance to immigration enforcement while you're on duty during work hours unless you're required to do so by state or federal law. And we'll get to some application of that concept in a little bit. And then the board is required to be told about any sort of immigration action, law enforcement related to that in a manner that ensures privacy and confidentiality of families. All right, next slide, please. So we've shifted from the board bylaw that's typically adopted by boards to the AR, which is typically adopted at the superintendent level. Now, I know that some districts do differently. Some districts have boards adopt the ARs. Some districts have the boards see the ARs, but they're technically adopted by the superintendent. I wouldn't change your practice because of this particular one, but I just wanted to flag that we've now moved from what the sample board policy covers to what the sample administrative regulation is going to cover. And for the most part, it covers these 4 situations that we'll get into. And this was alluded to by Kristin, but I just want to touch on a little bit longer. So most ICE warrants are administrative, which is different than a judicial warrant or subpoena. If a judicial warrant or subpoena is the one that is the Fourth Amendment one, right? That provides a basis to do a search or seizure under the Fourth Amendment. Administrative warrants are typically not signed by a judge, and so they're not in the same sort of category. But it gets complicated because there are some immigration violations that are civil. So unauthorized entry, for example, is a civil violation. But there are some immigration violations that are criminal. So if you fail to depart after being told to, after you've been removed, you illegally re-enter. And this matters because there's various sort of, and I'm not an immigration attorney, but I can just sort of generally say that if you have a criminal violation, then your ability to get documented and other sort of related stuff is much more difficult than if you don't. So some of you may know this from working with your families, from other experiences, but it really does matter. And school staff is not, and even most school attorneys are not going to be deep in this stuff to really sort of know the difference in a really nuanced way. So it's complicated, and as Kristin mentioned, we don't expect frontline staff to be the ones making the differentiation between a judicial warrant or administrative warrant, because it's just not easy and it's complicated, and you guys are not for the most part going to be lawyers that are sort of doing it. Okay, we're going to walk through these scenarios, these situations. All right, next slide, please. Okay, so this one is you get a request for information or documents. So that could be a phone call, could be an email. As we'll get to, it could be someone coming up to the district office and knocking on the door and saying, "Hey, I'd like this information." So under this regulation, the way that it's written is that you would only release it with parent consent, a court order, or judicial subpoena or warrant, not necessarily an administrative warrant. You do need to give the families notice of a request if their family information has been requested. So that's what the regulation says. Next slide, please. Okay, second scenario. So I'm an ICE officer. I'm requesting access to a particular student or to school grounds. Similar kind of constraint, right? Only granted upon consent, court order, judicial subpoena, or warrant. In general, we would be noticing the families of this. There is some carve-outs if the court order or judicial subpoena or warrant prohibits it, or if they're suspecting child abuse, neglect, or dependency, because it gets complicated, right? Like depending upon who's coming and why they're coming. And so there are some carves out. The regulation does ask that everyone, including officers, register as any other visitor would register. So in addition to 514 5.13, you should take a look at your visitors and outsiders policy, because you cannot treat law enforcement differently, but you can treat them the same as any other visitor, with a few exceptions. So if you don't have a visitors or outsiders policy and you basically allow anyone to come onto campus, then you may be basically acknowledging that certain aspects of your campus are public spaces. This doesn't just apply for immigration enforcement. This applies to, First Amendment audits and other related things. And so it's definitely something to take a look at and make sure that your frontline staff are comfortable with what that policy says. You have proper signage so that you can enforce and sort of apply it appropriately. All right, next slide, please. Okay, so this is where I think people get a lot more concerned. So I have a law enforcement officer on the property. What do I do? The regulation talks about if you have an administrative warrant and no exigent circumstances, you must first get direction from either the superintendent or designee. Typically, it'll be district counsel. You're going to be asking the officer on the premise for the basis for their request, their credentials, their name, their contact information. And again, it's the same sort of notice requirement. When there's a court order or judicial subpoena or warrant and still no exigent circumstances, you're going to want to redirect the officer to or tell them to consult legal counsel, because that's really what they should be doing in most situations. And I know that there are questions about, well, what's the difference? How do we know? And so I'm going to address it slightly. And I'll just say that, unless an officer is like, get out the way, I'm coming in, open the door now. That's more like exigent circumstances. And this is true really for any law enforcement, not just immigration law enforcement. But your frontline staff can say, do I have to comply? Or you can say, is this a judicial warrant? You can ask questions of the officer. And we'll get to that in a little, but there's nothing against that. Like, it's definitely something that should be part of the training. And whether the officer, however they answer, they might try to evade the question, but you can really say hey, I need to know, do I have to comply with this right now? Or can I call my superintendent? Those are questions you can ask. All right, next slide, please. Okay, so under exigent circumstances. So that could happen immediately. You could have a bunch of officers coming on campus. You could have an officer who initially comes onto campus sort of without exigent circumstances, but then something changes and all of a sudden it becomes that situation. The regulation says comply with those directions immediately. Do not impede the officer. Do not get in the way. Do not try to slow them down, because that will put individual staff members in legal jeopardy, as well as the district. And so even if you think that the officer is exceeding their authority or acting outside their authority, it is not for the frontline staff to make that call and then say, actually, you can't do that, even though you're telling me that you have the authority to do that. Afterwards, you document. There's things in the regulation that talk about what you should record, any information you have, things like that. There was a question I saw about whether or not you can video. So that's a tricky one. You should talk with counsel. But I would say that sometimes video would be deemed to be impeding an officer. If you have, security cameras on campus, obviously that's going to capture video. But we really want to not only protect our students, but also protect our staff from doing things that would put them in jeopardy. All right, next one. Next slide, please. Okay, so Kristin mentioned detention or deportation of a student's family member, parent, guardian. The regulation does talk about releasing the student in that situation to the emergency contacts in the student information system or to an individual with a caregiver's affidavit. There's some piece in the AG guidance about like other people, but that gets very fuzzy and gray in practice, and you really want to use your existing systems. And remember that, that those systems could be the subject to a judicial warrant or a subpoena requiring you to turn over those documents. There is a requirement to then notify students and those contacts and anyone else taking care of that student with the fact that under certain education code, students can continue to meet the residency requirements even if there is some movement among family members and things of that nature. So there is a state law that sort of overrides sort of your typical residency requirement if a situation where a parent or guardian was detained or deported. There's also language in the resolution that would encourage families to keep their emergency contact information up to date and to recognize that the information is only used in certain situations. Next slide, please. Okay, I'll turn it back over to Troy.
Thank you, Josh, and thank you, Kristin. I appreciate your careful presentation of these issues and with the knowledge that this is a fluid situation and not everything is cut and dried at this point, and that will probably remain the case for some period of time. We have quite a few questions in the queue, so we're going to get to those. Some have already been answered, but we may repeat them because we know it's a lot of information to process, and often it's more helpful if you isolate the questions and answer them one by one. It's easier to absorb the information that way. So the first question in the queue asks, is it recommended that all LEAs adopt the sample CSBA board policy and administrative regulation of May 1st, 2018? Will there be another update? If so, do we wait or move forward with adopting? Also, is the sample still relevant or outdated in any way?
So I touched on that early on. So we are updating it. It'll come out shortly based upon the latest AG guidance. I mentioned early on that the guidance, the 2024 guidance, says that you should update it by May 1st. You should talk to counsel whether they feel like you have to update it or not. But we are providing that sample, revision to the sample, so that if you want to, you have something to start with. But we want to reinforce that we're not saying you should update word for word our version. Our version is a starting point, not an endpoint for your policies.
Thank you, Josh. The next question I think we covered, but if we just want to revisit it quickly, I just read that recent change included the ability to do raids on school premises.
Yes, so that is the rescission of the 2021 Biden guidance from DHS that expanded on a 2011 guidance, but that treated schools, churches, hospitals, and other areas as protected or sensitive areas that would be exempt from immigration enforcement. That has been rescinded. As I noted, we do not have a copy yet of the memo that was issued. What we have is a statement from the acting secretary of DHS, who has said that immigration officers will use common sense in how and where they enforce immigration. So no longer is it the policy that schools be off limits for enforcement. Be aware that it was always the case that immigration enforcement could incur in a sensitive or protected place if there were exigent circumstances, as we've been talking about. So a direct, immediate threat to health or safety of people or property. So they weren't ever completely exempt. But now they're just treated as any other place. And then the Fourth Amendment protections would kick in, as well as state law that Josh talked about not assisting with immigration enforcement. That is still prohibited by state law.
Thank you, Kristin. The next question, a number of people asked questions about this topic, so I'll try and combine them all into one question for brevity's sake. Can you talk about how far private spaces extend? Do they include the front of school or the sidewalk for drop-off and pickup? What if ICE or another agency were across the street in a parking lot? Schools are supposed to provide a measure of safety to students coming to and from school on their commute. How do all those spaces which are adjacent to but just outside of the building itself, how do they fall under this private spaces definition? Are they private or are they not?
So I can't give a black letter law answer. This isn't something that's been, litigated specifically. What the rule is it is a private place and not public if there is an expectation of privacy. Most of the law is around people's homes, their cars, and personal areas. Most experts have interpreted inside schools to not be public areas, but the reason that the 2021 order expanded the protected areas protection was because there was a feeling that those areas that are near schools, hospitals, churches, etc., like the front sidewalk, like the parking lot, like bus stops, were prime areas for ICE to do enforcement. So my take is that the sidewalk, the parking lot, bus stops, things that are not inside the school are probably going to be considered a place where no one has a reasonable expectation of privacy. And there are some that might argue that inside the school you don't have a reasonable expectation of privacy. And that is maybe something that we will see litigated, but right now that is the interpretation.
So I'll just add to that. There is many districts, many counties are going to have a visitors and outsiders policy. We actually just updated that recently, and that, while not a guarantee of the definition of public versus private spaces, it's going to be a strong basis to make that determination. So, and also practice, right? So if you let folks walk through your parking lot, whomever, I don't know. I think it's unlikely that anyone would say, yeah, that's a private space. If you let anyone from the public walk into the front desk of a school and ask questions, same thing. If you have a playground that is open to the public, that you don't enforce sort of restrictions, I think it's hard. If people are sort of walking in and out of your school building, I think it's hard to say it's a truly, private space. So that policy and making sure you have training on it and signage around it is going to be important, not as the determining factor entirely, but as a strong influencer on what in practice is going to be sort of your public versus private spaces.
Thank you both. Next question. If there is an attempt to enter a school with a warrant, would it need to have specific names attached to the warrant that ICE can access? Or could a warrant be for searching for any students they want with blanket legal allowance?
So a judicial or warrant or court order has to have reasonable cause for its issuance. So it is not under Fourth Amendment precedent. And remember, this applies to all law enforcement. So, but under Fourth Amendment precedent, they would need to have a very specific name of who the warrant is going after, or the type of records, it would have to have be signed by a federal judge or magistrate. It could be signed by a state judge, but we expect immigration warrants to be signed by federal judges because it's within federal purview. It has to be, there has to be a specific time for it to be executed. So if you get a warrant and it says it was supposed to be executed a week ago, it is not valid. Because it does protect people's right to unlawful search and seizure, it does have to be very specific. A judicial warrant is very unlikely to have a fishing expedition to just allow ICE to walk around and see if there are any kids they think are undocumented, or parents, or start searching through records. It's going to have to be, for a judge to sign it, it's going to have to be more specific than that. It's a really good question, one that has come up a lot. With respect to the administrative warrants, we are not sure what to expect there. Those are typically also specific, but those are, you do not have to allow entrance for those. So they're less of a concern. I think that you should expect a judicial warrant to have a very specific set of parameters, including the name of who they're looking for or who they want records about.
I just add to what Kristin said earlier is that, you should not be expecting your frontline staff to be looking at the date and time, or like determining whether a warrant is valid or invalid. That's, to the extent that you can, you're redirecting them to superintendent, district council. They're not with this document in front of them deciding, oh, I should or shouldn't comply. They can ask, but if, and that's really the extent of what's going on.
The next question asks, what actions are considered official designations as a sanctuary jurisdiction? I think what they're asking is what steps are taken to acknowledge or certify that a particular area or institution is a sanctuary jurisdiction.
So this is sort of it's not set out in law. It's sort of something that folks just started doing. So it's going to be up to the interpretation of the administration what a sanctuary jurisdiction is. So for example, California passed, I want to say it's SB 54. It's the law that prohibits local governments, including law enforcement agencies, from assisting with immigration enforcement. That was signed by Jerry Brown. It was called our sanctuary law. So that will probably be interpreted by the administration as something that could subject California to a loss of federal funds, because that is an intent to stave off certain kinds of assistance with immigration enforcement. If a city passes a resolution or a municipal code that says it's a sanctuary city, that might be sufficient. We just don't know at this point, and there isn't a constitutional provision or a federal statute that says what you have to do to become a sanctuary city, right? So, if a district passes a sanctuary resolution, there is a sanctuary district or a sanctuary county office of education, there is some risk there that the feds will try to come after federal funding. And these are questions and discussions that boards need to have, around their risk tolerance and versus what they think they need to do to keep schools safe and nurturing environments for students. And you really want to rely on legal counsel to help you have those discussions. But yeah, anything is pretty much fair game at this point, given the nature of what we're seeing as far as the directives for immigration enforcement. Erika, did you have a thought too?
Yeah, no, I think you hit it, because I just wanted to say that most of this is done through local, city, county resolution type things. And I know a couple school districts have done it. There's a question a little bit later on that I saw is, what does the task force for sanctuary task force that's being put together, how does that interact? This is something through the Department of Justice that is being put together, frankly, to look at what cities, counties, states have resolutions. What do those resolutions say? Because this is going to be part of what the Department of Justice and the new federal administration will be using to potentially look at sanctions against states and cities. So, I mean, there is that, this all kind of plays together. Unfortunately, there's also not a lot of specificity of what they're looking at specifically or what they're going to do with that information yet. This is all stuff that we will keep hearing about, and I think we'll keep hearing a lot about it over the next month or so. So that's kind of where we are with that.
Yeah, and I'm hoping that we'll see some statements from the governor and our attorney general about how they interpret these things. I think that could be helpful, I imagine, and I hope that they're working on that now. They have a lot of irons in the fire right now, and it's only been a couple of days, so be on the lookout for kind of their take. But at the end of the day, the feds do hold the purse for federal funding, and so we just need to make sure that we're acknowledging the risk there.
Thank you all. We have a lot of important questions. Unfortunately, we're getting more questions than we can answer at the time allotted. They're coming in faster than we can respond. But I would point out from scrolling through the Q&A section that the majority of these questions have been answered in some form. So do remember that we will be sending out the presentation deck and a recording of this webinar to everyone who registered, not just the people who are online right now. So if you don't get your question answered, there will be another opportunity for you to go back and play this at your leisure and be able to collect those answers. The next question says, how do we protect school and district employees from getting caught between state and federal laws? Is there a definition or clarity about what, quote unquote, standing in the way of immigration enforcement is?
Yeah, Josh, you had some good thoughts about that when we were talking earlier, if you don't mind.
Sure. I mean, I think that question both goes to sort of is the institution standing in your way, or is an individual standing in your way? And, most of what we're talking about for the district or the county office is going to be state law. So if Trump or some administration is going to challenge a state law, we'll just see how that plays out. And it's really sort of out of our hands in some sense. I think on an individual level, I think as you train your frontline staff in particular, the suggestion would be to really help those staff asking questions of law enforcement. So, do I have to comply right now, officer? Officer, do I have time to contact my boss or superintendent and ask for further directions? Officer, would you be able, I've been directed to, basically redirect you to a district counsel. Can I give you the information? Most of the time, I've worked in a number of districts, and having dealt with law enforcement, it's not going to be exigent circumstances where they're going to just have to run into the school. Usually they're asking for information, they're trying to track somebody down, and then redirecting them is perfectly appropriate. You can say, are there exigent circumstances? Do I have to, you can ask those questions, obviously in consultation with whoever's doing the PD. But that's the kind of stuff that would allow you to, sort of not stand in the way to know whether you have to comply. There's a question later on I alluded before about like filming. And again, like you don't know, right? So if you start filming and the officer says you can't film, it really isn't going to be up to the individual employee to say, actually, I'm not impeding you. You can function without, you can function just fine with me videoing. You don't know the context. You really don't know. And so that's not a blanket rule against filming or that kind of situation. But it's a word of extreme caution in that kind of situation. Again, hopefully there are going to be cameras at the site that will be recording for you, so you don't have to actually sort of worry about that. If you can collect information, say, hey, am I allowed, do you have time to give me your information, etc. Those are the questions that can be really valuable, and also are consistent with what's in the board policy and the administrative regulation.
Our hope is that these interactions are are reasonable, and that, you know, they're willing to take the time to have a conversation and let staff do what they need to do as far as reaching out to administration and legal counsel to get their questions answered. That's our expectation. And that this sort of back and forth professional discussion about what they need, what they're looking for, what they've got as far as documentation, who they are, that's all done in a very respectful, mutually professional manner, and that staff can, you know, then get the information that they need, whether to let them in or not. And that's, you know, that's what we expect and hope we will be seeing if indeed we do start seeing enforcement on school campuses.
I am in San Diego County. We are part of state and county sanctuary laws. However, our sheriff plans to participate with new administration laws. How can we meet both requirements?
Yeah, I mean, I think that the answer we just gave is the best that we can provide at this point. There The Cal Matters reached out to a number of sheriffs, every sheriff in the state, and asked them, you know, what their plan was, and most of them are saying they're going to follow state law, but it's really not up to a school district to tell a sheriff, you know, what they should and shouldn't be doing. You just have to follow the rules as we've set them forth and what is in your policy, and just be consistent and follow your policies is the best advice we can give, you know, as far as dealing with outside agencies and how they may interact. And Josh made a really good point, which is that this is what you would do anytime law enforcement came on campus, right? And so if you have sheriffs coming on campus, it's the same practice as if it's an ICE officer. The what they're doing might be different, but you're going to react in the same way and just be consistent. Another thing is, you know, maybe it's worth reaching out to your local law enforcement agencies and tell them, hey, this is what we're hearing. This is what we think is going on. And what do you think? What should we do? Do you have any thoughts? Are you intending to assist? What are your expectations? You know, that kind of a thing. And have those conversations now. And part of kind of, you know, what I said about being proactive and getting ahead of this and being ready might be just having some conversations with those folks and get their take on it. You know, I know a lot of LEAs have a really good relationship with their local law enforcement. And so the county sheriff or your local police department is a nice place to maybe start having some conversations and understand what their expectations are and what they expect.
A member asks, are we using the language protective sensitive areas versus safe havens? I would just say that the sensitive terminology is the official terminology, and safe haven, although that has a nice ring to it, you know, potentially could be overpromising given the instruction of the recent directive. And I wouldn't want you to overpromise or mislead a community about what you can do with regards to immigration enforcement. So obviously that's going to be a decision that each individual LEA would make, but please keep those considerations in mind.
Yeah, the sensitive and protected areas terminology was part of the Biden 2021 guidance. It was originally sensitive when it was issued in 2011. They changed it to protected. I've kind of been using them interchangeably, but that's gone now. That federal guidance does not exist anymore. And so that terminology, at least as far as federal enforcement, is no longer part of the legal landscape.
A member asked, do administrative warrants apply? I know we've been over this, but just very briefly, if we could recap the difference between the administrative and judicial warrants and what that entails.
Sure. So administrative warrants are issued typically by immigration agents, not judges. They might be issued by an immigration judge. And this is why Josh has repeatedly said we do not expect frontline staff to be able to make these distinctions, right? This is for legal counsel to look at. But in a nutshell, an immigration warrant is going to be issued typically by the Department of Homeland Security. It's going to be signed by an immigration officer. It typically will use the word alien. That's the information that I have gleaned from my research. And it'll state that the authority for the warrant comes from immigration law. It will not say that the issuing authority is a court. A warrant from a judge and a court will say that there's, the signature will say the name of the judge, and it will say judge, first district federal court or something like that. It'll be very obvious that it came from a court. And, for example, I saw a question like this. I don't think this is going to happen. I'm not suggesting this will happen, but if you got given a warrant that had a judge's signature on it and that was fake, I don't think there's any expectation that people are going to be able to make that determination. So I think reaching out to legal counsel is important, but those are the kind of nutshell distinctions between a judicial warrant and an administrative warrant. And I think for a lot of us, this is the first time we've even been dealing with this terminology. So I appreciate the questions, because I think that we're all our heads are spinning a little bit trying to get a hold of all of this new information. And so hopefully just kind of giving you that distinction will help.
We had a couple questions about this next topic. Would completing the DACA application for financial aid count for keeping record of immigration status? Counseling departments in high schools assist students with financial aid applications. There were several similar questions about information related to DACA that could be revealing as to immigration status. And so what is the responsibility in terms of providing that information?
That's a really good question that I haven't really gotten a hold of yet. Josh and Erika, I don't know if you know the answer. I mean, it's really an issue not as much related to current events, but an interpretation of AB 699. The Attorney General's guidance may have some more information. Josh, are you aware of anything specific?
I haven't seen anything specific on that point. I would say as a general rule, if that information is being kept by the counselor versus the counselor is just sort of made aware of it in assisting the student, right? There's differences there. When you're filling out your, online, like, FAFSA or whatever, right? Like that information is going to be housed in the system, not necessarily at the district level. But I definitely would be cautious if, the counselor is like writing down notes about like, oh, these students are the ones that, are undocumented or have, because of what they know, that would potentially be something to flag and talk to your legal counsel about. If it's the only way to do it, but if there's another way of doing it that doesn't require to track immigration status, that's what the law typically would favor.
Right. And recall that those records are not disclosable without consent or warrant at this time. But I do understand the question is more about compliance with AB 699. I think Josh has provided a good answer.
Mm-hmm. Yeah, I would say Josh's answer is really good because, the whole piece with 699, the issue is don't keep the information. If you don't absolutely need it, don't hang on to it. And as Josh said, if you're helping them fill out the forms and that sort of thing, those forms then go to another entity and to, another system. Don't just save a copy in your own system, though, just so you have it, because that is the kind of thing that they could potentially come back and look at.
Yeah, and I think that the intent of AB 699 is to take you out of the difficult position of having records that they're asking for. If you can just say, we don't keep records of that, I think that was the intent of not maintaining those records, was really to protect LEAs from, having to be caught in between this federal and state law. So to the greatest extent you can avoid maintaining those records, that's what you want to do.
Someone asked, can staff just state student is absent that day? And to broaden the question, maybe we should just address in general, what are your responsibilities to provide truthful responses to law enforcement?
I'd say that there's two pieces to that. So do not lie to law enforcement. Just don't do it. But also you're releasing student information. So if a random person came up and said, "Hey, is little Joshy at school today? Are they absent?" Right? Like that's not something you should be telling anybody. So you have to be very careful. Not only is it not lying, but it's, as Kristin mentioned earlier, FERPA protects student information from disclosure without, certain conditions. So, again, unless there's exigent circumstances being clearly stated and, saying you have to answer like that's not information you can provide.
Yeah, I would just echo Josh. I understand the impulse is to protect a student, but it's not going to help the student and it's not going to help the situation. So I think just, asking the questions, do you have a warrant? What are you here for? What's your name? And just following the same process and being consistent and following what's in your policy and administrative regulation is just the way to handle any of these kind of visits.
Another angle or tangent from the obstruction question we addressed earlier. If there's a locked gate or door, an immigration officer is attempting to enter and the staff member does not believe they have the appropriate judicial warrant as outlined by the Attorney General guidelines, is that staff member required to assist and unlock the door anyway at the discretion of the officer?
Go ahead, Kristin. I'll jump in after you.
Yeah, I mean, I think in that scenario, technically, no, they're not supposed to open the door. We're not supposed to assist. But what are expectations of staff when someone is there with, a gun and is insisting on coming in? I think is going to have to just be dealt with on a case by case basis, and they should call for help before making that decision. And I don't think we should ask frontline staff to even be in this position, and they should have an somewhere to call to get assistance for that. I mean, I think they can say you're not allowed to go in there, and once that is said, if the officer insists, it's going to be hard for them to keep them from entering.
Implicit in this question is that the frontline staff person who is at that front gate believes that the officer doesn't have the basis to enter. And again, we want to reiterate, that is not the call that person should be making. So they can ask questions. They can say, do you have a legal basis to enter immediately? They can say, am I required to follow your instructions right now? Do I have time to contact my superintendent? Like, those are all questions that can be asked. Depending upon how the question is phrased, the officer might say, well, yes, like I do have a basis to enter because you're opening the door for me. It's not a judicial warrant, but you open the door for me. So, but if you say, do I have time to contact my boss to ask for, advice, and they say no, well, whether or not you believe that to be accurate, they're telling you no. This also goes to the training piece. I mean, whether or not an officer is acting intimidating, sometimes people can just feel intimidated by an officer. And so it's important to, to ensure that, officers are, that the staff who are interacting with them, understand, maybe role play a bit, just like, every officer that I've interacted with at the site level has been super respectful and it's always gone fine, but frontline staff might get nervous, they might get worried. And so that's really where the training and the support and can really come in and help.
Yeah, I don't think we expect that kind of situation. But I think, yeah, just training staff to ask for time is a really great way to handle those situations.
Our board policy and administrative reg 5145.13 the only policy and regulation that needs update? Should other policies and regulations, such as those on student records, also be updated?
So we will be releasing a few of the related policies around student records and district records and updating those, although the main gist is going to be in 514, 5013. And I also mentioned visitors and outsiders. Given the number of questions about, what's public, what's private, I would say I think we updated that one very recently in the last update or two. But that's the one that you'd also want to probably take a look at and make sure that you understand it, that you have signage around it, trained, that folks are trained around it, and that you actually implement it. There's a question later on about if a school site is or a playground is sort of partially open to the public. It's going to depend. If you allow members of the public to walk through that space and there's no signage, it's kind of a public space. I mean, I don't want to say for sure, but versus if it's all fenced off and you have a security guard or an access panel, right? And like anytime somebody who you don't know enters, steps onto that property, you say, "What are you doing here? Please leave," right? That's a very different, no pun intended, but sort of on the ground reality, that will influence whether something is deemed to be public or private.
Is there a recommendation on how to verify age for enrollment? We currently ask for birth certificates, which basically can show someone's immigrant status.
Yeah, so this gets back to the principle that Josh was talking about, which is you should use something else if you can. And most of the advice is around residency, right? It's much easier to do that as far as obtaining utility bills and things like that. I am not sure off the top of my head what other kinds of things you can use for age of enrollment other than birth certificates. But you should not be maintaining copies of those. If you had to view them for enrollment, then you wouldn't want to maintain any copy of anything that could show immigration or citizenship status.
If schools or districts do not maintain immigration information on students, what language should be used to articulate that to immigration enforcement?
I think that this is something that if they came looking for records, this would be a much longer process. This is not a situation where you have a school secretary is going to get an administrative warrant for records and say, "Oh, we don't have those," and hand it back. She's going to say, "Okay, thank you. I'm going to send this over to my superintendent. Legal counsel is going to look into it and we'll get you the records as requested if we determine that this, subpoena or warrant is appropriate." So I think that for record requests is not going to be an immediate demand that they are able to just take records right then and there. So I don't think staff needs really a script for that. I think this is going to be in the response to any kind of warrant or subpoena for records, which is going to be, we don't maintain these, so we don't have them, and that's going to come from legal counsel.
Can we change our policy that all document requests must go through our district office? So any ICE warrant would have to be presented to the district office versus the school site.
The answer to the first question is yes, you can change the policy so that all requests for documents have to go to the district office. If someone arrives on campus or a school site asking for records, you can redirect them with the caveat that, if they have a judicial warrant and I'm going to go in and I'm going to collect your computer or your paperwork in this area, and they say you have to comply right now, you have to comply.
Someone's asking what happens to the machine that some sites have where visitors have to put in their driver's license. Is that still something they should use in this current scenario?
Yeah, some school sites have, I've had to do it when I'm there for an investigation or something. I have to put my ID in. If, I think that what we would recommend is to follow your same policies, practices for everybody that comes on campus. So what do you do when law enforcement comes on campus? What if a sheriff's deputy comes on campus or a police officer? What do? Do you make them put their ID in? Then make the immigration enforcement officers do it. Just follow your standard policies. And if they push back, then, that's another time for staff to call for help. But they can say, this is what we require of every single visitor that we have on site, and that's our policy. And I think that's the script.
The
I
next
also
question I asked,
Can
yeah,
I
go
just
ahead.
follow up? I wanted to note on the question about birth certificates. There are some other things you can do, and I apologize for not thinking of this right in the moment. But you can get an affidavit from the parent of the student's age. You can also have hospital records, a physician statement. There are other ways to obtain the age of enrollment other than the birth certificate. So that's something that you could check in with your legal counsel about, but there are some options.
Schools are responsible for student safety on their way to school and home. What happens if ICE picks up a student on their way to school or home? I guess he's asking you what responsibilities or what steps should a district or an LEA take if one of their students is apprehended?
I don't know that there's any specific legal obligation, but I think you would notify their parent or emergency contact immediately if you come into that information. And at that point, it's really, up to the parent and your kind of policies about what you are going to do to assist parents. So you could provide them with what you give out in your annual notices as required by AB 699 about immigration rights. You could provide them with that. You could provide them with a place to go to look for referrals for immigration attorneys. It really is going to be an LEA by LEA basis on how you want to help parents who are in some sort of situation like that. But that is really a discretionary call on your part. Josh, do you have any other thoughts on that?
I think you covered it well.
Thanks.
Uh, this question is from a superintendent perspective. They're wondering if, as a superintendent, they can take a few minutes to consult our policies and ask questions of ICE. I know we said earlier that the superintendent or their designee can be the person to receive these questions, but if you are the superintendent, are you still allowed some time to get your ducks in a row before you respond?
Yes, and certainly, I think the same questions could be asked by literally anyone, not just frontline staff. Do I have time to consult? Can I get back to you? You know, are there exigent circumstances that require me to comply immediately? I would like to redirect you to my counsel. Here's their information, like those sorts of things. Um, it may be that only the soup has the counsel's information, right? So you got to go to the soup. Um, uh, and again, this is pretty similar to law enforcement interactions in general. Um, that you're going to want to sort of redirect, to counsel and, when there's a warrant of any sort, regardless of whether it comes from, ICE or not.
Yeah, I think the superintendent is sort of just a place to where there is access to outside counsel, and that's why we recommend that for staff. And because the superintendent will presumably have a good handle on the administrative regulation and the steps that are required to be taken, but mainly as just sort of a central place where there is some authority and the ability to contact legal counsel. We don't expect superintendents to become immigration experts overnight, certainly.
As we approach 90 minutes, I'm going to try and find questions that mine a completely new topic, not just explore a nuance of an already answered question. So if we don't get to your question, please know it's only because we're trying to cover the most territory possible here. Someone asked, normally we have to call police on students for certain situations. What happens if the parent gets upset, given that the student who the police is called on may not be in the country legally? So I guess another way to phrase it is during disciplinary actions that involve law enforcement agencies, what responsibility does the LEA have, knowing that involving law enforcement could expose the student as being undocumented?
So I would say that in general, if you feel the need to call law enforcement regardless of immigration status. And that question might prompt you to say, look at what are the scenarios when you call law enforcement, and do we really need to call law enforcement in these scenarios? But I wouldn't only call when there's not an immigration situation, and then don't call when there is. Like that's not because in general you're calling law enforcement because of safety issues, and so you need to sort of address that promptly.
Yeah, I don't think you want to get in a scenario where a kid ends up hurting another kid because you were afraid to call law enforcement because of their immigration status, because then you're gonna have a different upset parent. And I think it just goes back to what we've been saying, which is just be consistent, but also, as Josh notes, look at your policy. Are you calling law enforcement because you need to, or because, you know, it just is easier to let them handle it? But either way, always consistently apply your practices regardless of immigration status.
Should a bus driver handle ICE in the same manner as the schools? What about if you contract for bus services? Can we hold our vendors to our policy if not specifically spelled out in the contract?
So you should take a look at your contract to see to what extent you require any vendor to, this applies to third-party vendors that interact with students in any capacity, bus drivers, counselors, after-school providers, all that sort of stuff. So you should take a look at your contract and see, what it says about compliance with policy, awareness of policy, trainings, things of that nature. And potentially, yes, but it really depends on what the contract says and the responsibilities of the employee of that third-party vendor.
And for your own staff, yeah, that's a really great question. Definitely include them in the training, but it's going to be the same thing. Do I have time to call my superintendent? Do I have time to call legal counsel? What do you need? Same exact process. It's going to be a little more difficult because they're on the bus and trying to supervise the kids. But I think that's a really excellent point that you could see enforcement on buses and making sure your bus drivers, your own employees, are trained, and if it's okay, and if the contract allows for it for the vendors, that they be trained as well. And I'm hopeful that that kind of thing does not go on, but I guess we'll see.
We'll take a few more questions. If we as board members become aware of ICE on campus, would it be good or bad to go to the campus to be there to support office staff in directing ICE to contact legal counsel? My thought is that being there as a person of authority may give staff facing law enforcement some sense of security in a difficult situation.
Go ahead, Kristin. I'll jump in after.
No, go ahead.
Oh, okay. So, as a former board member, I am very sympathetic to the motivation behind wanting to show up as a board member and support your staff. But as a board member, you are not the boss of anyone. You are 1/5 or 1/3 or 1/7 the boss of your superintendent. And oftentimes going to a site where there is that kind of action can actually make it more complicated and more challenging, particularly if the board member starts saying, do this, do that, or don't do this, do that, differently than somebody else. And you as a board member kind of have authority, but it can complicate the situation very quickly. That being said, afterwards, going to a school site that has an experienced situation to support and ask what they need, not to direct, I think is perfectly appropriate and very helpful. Obviously, you want to be in touch with your superintendent to coordinate, right? To recognize that, you're not sort of getting in the way. But I would be cautious about, as a board member, trying to involve yourself in the interaction with law enforcement.
Yeah, I agree with Josh.
As we know, employees and frontline staff are more at risk to be arrested for perceived interference. What protections will employees have if they are arrested?
So I assume that means if they're detained. And I only make that distinction because if you are arrested, right, like that is more of a criminal violation variety. Any law enforcement can come in and arrest an employee. They believe that they violated a crime. They find out they work at a school site. They may not want to wait, and they just come on site and they arrest you.
Excuse me, Josh. I think the question is asking if they are arrested for obstruction because they reference interference.
Oh, I see. Thank you for clarifying. So if an employee is, I'd say, impacted during their job duties, then in many situations, there is some protection, legal protection that the district would provide to them, but not always. And if the district is saying do not interfere, and a staff member jumps on the back of a law enforcement officer to try to interfere, the district is unlikely to be required to provide protection to that kind of behavior. So you know, there is a bright sort of, there's clear things on either side, right? And then there's a gray area in between. But in general, if you're sort of operating in the sort of due course of your responsibilities, the district does in general have an obligation on the civil side to defend you. Criminal is a little bit different and more complicated, and you'd want to sort of talk to your legal counsel about that.
Yeah. But we don't think that asking questions about warrants and getting officer ID information is obstruction. I think following policies is the best way to avoid anything like that.
Yeah. There was a question in there about whether or not somebody could escort an officer around campus, and you should just ask, officer, I'd like to escort you around campus. Am I allowed to do that?
Yep.
And yeah, see what they say. And if they say no, then you can't.
And we have another question about DACA, but related to employees as far as students. What, if any, protections exist for school staff that are covered under DACA?
I'm not sure I understand the question. Is it?
I think it's in relation to providing information as to their immigration status, if they're employees.
That's a good question. I think that, so in California, employees have a privacy right to their personnel records. We don't have the same set of specific laws about immigration records of employees, but I would, require some sort of subpoena or warrant to turn over any kind of records. And also proactively take a look at what kind of records you're maintaining for those employees, and if there's a way for you to not maintain records of immigration status. For certain things like visas and other things, you don't have a choice, and you have the I-9 and all of those federal rules apply ahead of state law, so continue to follow those. But I think that is a case-by-case question, and you would just call legal counsel if you got a request like that.
We also have a question about whether anyone is aware of service providers, whether it's a law firm or a nonprofit, that can provide staff training on how to handle issues like this.
I'm not aware of any organization. The National Immigration Law Center is where I found the information, breaking down the administrative warrants versus the judicial warrants. They have pretty good guidance around that. I'm not vouching for the legal correctness. Based on my research, what they have is correct, but everything needs to be taken with a grain of salt. But they might be a place to start to look for some assistance with those kind of trainings. Keep in mind that there has been some, I don't know what word I want to use, but those organizations, non-governmental organizations and nonprofits are referenced in the executive order, and they're being told not to assist immigrants with avoiding ICE. So just be aware that situation exists for them, and they may not have a lot of options or resources right now. But I know that a lot of advocates are still out there assisting folks.
Thank you. There are still more unanswered questions, but I think almost all of them touch on topics that we've already covered. And I know there's requests for more information. So given the great interest and some of the really granular questions we have, I think we're going to produce an FAQ of some sort or another guidance document to ask to respond to the more commonly asked questions. So I know a couple of you requested that, and certainly there's a need for that, and we'll begin working on that. We also do have some immigration resources currently on the CSBA website at csba.org. If you just go to your web browser and type CSBA immigration resources, it will come up first hit on the Google responses or whatever search engine you use. And then we also have the direct URL, which is displayed there. There's a lot more to come on this issue. Unfortunately, it's very complicated and there's not a lot of clarity about some of these critical questions right now, but we are going to keep you updated with information and interpretation as soon as we get it. So thank you to everyone who joined us today. You'll be hearing more from us on this and other topics. Take care.